course, but can I warmly welcome and ask you to give a warm welcome to Thomas Grant, who will talk to us about Sydney Kentridge.
Thank you very much, Treasurer, for inviting me to this magnificent hall. I'm a Middle Temple man myself, but I always love coming up to Gray's Inn, seeing this superb hall, which is, I would say, on par with our own Middle Temple. Some people might differ. Now, I'm here tonight to talk about the life, work, and legacy of the man that our Treasurer has mentioned, Sir Sydney Kentridge, King's Counsel. Now, I'm pleased to say that Sydney will be celebrating next week his 103rd birthday. He sends his apologies for not being here tonight, but I'm delighted to say that he's represented today by his daughter, Eliza, and his son, Matthew, and also represented the Kentridge family are Matthew's wife, Janet, who is herself, as many of you will know, a member of Matrix Chambers, which is, of course, part of this, located within this inn. And equally special is their daughter, Emma, who I'm told is currently reading for the bar and hopefully will be the next generation of Kentridges to appear in the courtroom. Now, as our Treasurer mentioned earlier, I, a few years ago, 3 years ago, published a book about Sydney. And it's fair to say that I only got to know him well, or at all really, in the last few years. Really, I think I met him for the first time properly in about 2019, 2020. But when I became barrister myself many years ago, in the 1990s, I was, of course, very well aware of his reputation from a considerable distance. And I knew him then, and he was known by everyone at the bar at that time as the doyen of the commercial and the constitutional public law bar in London. And at the time, he seemed to wear, especially for little minnows like myself, an almost sort of mystical aura as the great advocate, capital G, capital A. Every time one opened up a law report, one seemed to find his name in some great case in the House of Lords or the Court of Appeal, covering a huge area of law. So just to give you a few examples of the work I was doing in London when I was studying the law reports and seeing his name. He appeared in the litigation concerning the Hunting Act. Some of you may remember that there was an attempt back in the 2000s after the Hunting Act was brought in by the Blair government to have it set aside as unconstitutional. Sydney likes to remember that case. It was the case where he appeared in front of, in total, 12 judges all the way to the House of Lords, where they convened a panel of 7. And he says, it's the only case where I lost 12-0. It was a quixotic attempt, but a valiant one. You'll also, some of you, the students here, will probably have read another one of his great cases in the 1990s, M and the Home Office, the first time that a Home Secretary or a Cabinet Minister at all was found guilty of contempt of court. More recently, you'll remember his work in respect of the Chagos Islands, work that's been carried on to this very day, with other people picking up the baton where he left off. And also at the same time, he was appearing in numerous Privy Council appeals from Caribbean countries, which then and still now had the death penalty, and he would appear generally pro bono, acting on behalf of defendants who had been sentenced to death and who were appealing to the Privy Council. And a number of people owe their lives from that period to Sydney's advocacy. And I was just thinking last week, I was reading, as I'm sure all of you were, about the litigation, the trial in Northern Ireland of Soldier F, prosecuted for murder in respect of the events of Bloody Sunday. And it occurred to me that the reason why Soldier F is referred to anonymously rather than by that person's actual name was because 25 years ago, during the Savile inquiry, Sydney had been instructed on behalf of the soldiers, where Lord Savile had wished to de-anonymise them. There was a big litigation which went all the way to the Court of Appeal, and Sydney prevailed in persuading the courts that it was vital to preserve the soldiers' anonymity. And that anonymity obtained effectively by Sydney 25 years ago has persisted to this current day. Now, those are the kind of constitutional cases Sydney was arguing in England during the 1990s and the 2000s. But he was also active and very active in the commercial and the libel, the common law sphere. And again, I know there are a number of students here today, and I'm sure you'll recall a lot of the cases that are part of the sort of legal furniture of student education. Sometimes we barristers and perhaps judges look at these cases as well. Hamilton and Al Fayed, the beautifully named Linden Gardens of Lunesta Sludge, very important cases, some of you remember. Fairchild and Glenhaven, and of course, Three Rivers District Council and Bank of England, all cases that Sydney argued in the Court of Appeal or the House of Lords. Now, Sydney next came to my attention in 2013 when I read in the newspapers of the news of his retirement, and this was a much discussed event at the time, because in 2013 Sydney was 90 years old, and as I'm sure everyone will agree in this hall, it is unheard of and possibly unique for a barrister to be practicing into their 10th decade, and certainly to be doing so at the very highest level. I mean, it is a story which is often told, I think it deserves retelling, that Sydney appeared before the Supreme Court on his 90th birthday in November 2012. And he appeared in a very important case on the law of legal professional privilege called Prudential. Three-day appeal, vast array of leading counsel appearing. And I think it is probably the case that no other advocate has appeared before the House of Lords of the Supreme Court, aged 90. And it was such a momentous occasion that leading counsel for Sydney's opponent, a man some of you may have heard of called Lord Panic, did something which I suspect is unique to an English courtroom, which is that as he stood up to open his appeal to the Supreme Court, he publicly wished Sydney a happy birthday. I've never heard of anyone wishing a happy birthday to anyone in an open courtroom. But then something equally unique occurred, which is all 5 members of the bench endorsed Lord Panic's felicitations on Sydney's birthday. And Panic was quick to add then that his wishes on Sydney's birthday were, quotes, "without prejudice to my submission that my learned friend's case is entirely without merit." I'm pleased to say that Sydney won the case. He retired shortly thereafter at the age of 90. Now, about 7 or 8 years later, I was collared, I think that's the right phrase, by a very eminent barrister who many of you will know, called Edwin Glasgow, who came up to me with an air of urgency and said, "Really, Tom, Sydney's life has to be written, and you're the man to do it." And to those of you who know Edwin Glasgow, he's not a man you say no to. And I said, therefore, yes, without any qualifications really at all to do so, and therefore had to embark upon some pretty urgent work, not the least because the book really had to come out on Sydney's 100th birthday, in his 100th year, and I only had 2 years or so to do it. So I set about some pretty urgent research, and then I started researching Sydney's South African life. I had known that Sydney was South African. I had a vague idea that he had enjoyed an eminent practice in South Africa, but I knew nothing about really more than that, about what he'd done in South Africa. And I discovered an awful lot in a pretty short period of time. I say discovered as if it was somehow forgotten to history, what Sydney had done. Of course, in South Africa, Sydney was as revered in 2013 as he had been 30 years earlier, and equally revered in South Africa to the way he was revered in England. And I discovered essentially that he had had this previous life as an advocate before he came to England, which he had done in the late 70s, and gradually moved his practice to England during the 1980s. Now, I'm not going to give you a thumbnail sketch of Sydney's life. It was I'm not here long enough to do so. But he was born in Johannesburg in 1922. His father was a solicitor, a member of the South African Parliament, and a very active politician in his time. And I suppose any very old person has an intrinsic interest simply because of the fact that they have lived through events that seem so far removed from us in the present day. But Sydney's intrinsic interest is triple-fold, if I may say so. It's an extraordinary thing to think that Sydney went up to Witwatersrand University as an undergraduate in 1939. It's an extraordinary thing to think that he joined the South African Air Force in 1942. He landed in Sicily with the invasion force in 1943, and he remembers going to La Traviata in the San Carlo Opera House in Naples, bombed in total ruins in 1944, where he learned his love for opera, which remains to this day. It's an extraordinary thing to think that Sydney then, after he was demobilized in 1946, read for a second degree in Exeter College, Oxford, where he studied for 2 years. And one of his most vivid memories of his time in London, in England rather, in the mid-40s, is going with his father to visit Clement Attlee in 10 Downing Street in 1948. Very vivid memory he has of that occasion. Having graduated a second time, Sydney returns to South Africa in 1949 and is called to the South African bar. Of course, that's a critical moment in South African history, because that's the time when the apartheid state is created as a result of the National Party's victory in the 1948 election. The moment the National Party sweeps into power in 1948, as many of you will know, it is very swift in enacting a whole tide of legislation that creates what might be described as the apartheid state. Sydney is there practicing as a young man in Johannesburg as an advocate. And his early years at the Johannesburg bar are very much like anyone else's. Well, it's a very small bar, but anyone else's at that time, doing anything he can to earn a living, learning his trade. And one of the remarkable things he remembers about those early years in practice, the late 40s, the early 50s, is that in those days, there were large numbers of murder prosecutions going through the Johannesburg, Pretoria, other courts. And generally, it was the youngest members of the bar that were handed the briefs for these capital cases, because they were paid so badly. There was a very limited legal aid institution at the time, get paid a very trivial sum. And the older members of the bar didn't want to take on such underpaid work, and hence it fell to Sydney to have to defend. And he remembers multiple cases that he defended in for typically a young black defendant on trial for their lives. And it's a very rare thing to come across somebody who's still alive who can remember hearing, as Sydney does, the death sentence being passed on his clients. Now, it was, of course, a very bleak period in South Africa's history at that time, as an increasingly repressive police state was created, which enacted these swathes of legislation which deprived the vast majority of the population of basic political and economic and human rights, and criminalized vast swathes of human behavior. Now, one of the paradoxes of South Africa at this time, and for a number of years thereafter, is that whereas the national government, the national government regime was criminalizing so much human activity and creating this apartheid regime. The South African legal system was revered across the world. It had been for many decades. It was a very developed and sophisticated legal regime with a very developed and sophisticated jurisprudence and a very impressive bank of judges. So you have this paradox of having a judiciary which was very much attuned to the rule of law and the dispensation of a just legal system against the injustices being created by Parliament. And it was into that battleground that Sydney stepped. And the book that the Treasurer has mentioned that I wrote, and which was published 3 years ago, was called the Mandela Brief. And the reason it was entitled that was because of really the first really important case that Sydney argued in the South African courts. And that was the so-called treason trial, which was a trial which took up 3 years of Sydney's life between 1955 to 1958 or thereabouts. And it was a trial where essentially by this stage, apartheid had been in force for 7 or 8 years. And there was a large body of people who dissented against the state. And they were typically members of the ANC, members of the South African Communist Party, members of various trades unions who were active in South Africa. And the state decided with one fell swoop to arrest them all and prosecute them all. And there were, I think, originally 150 defendants on the basis of a grand conspiracy to undermine and overthrow the government. And they decided to create what they hoped would be a show trial. And they were all packed in, these defendants, into a courtroom in Pretoria called the Old Synagogue. It had been a synagogue and had been repurposed as a courtroom. And over a period of years, this litigation, this prosecution took place. And Sydney was retained alongside a number of other great South African advocates of the time to defend this huge mass of defendants who, if you look at their names now, they're all the great figures of the anti-apartheid movement, of course, principal among which was Nelson Mandela. And Sydney was allocated certain of the defendants, and other advocates were allocated certain other defendants to divide up and break down the work, the vast amount of work that had to be undertaken. Of course, we're talking about a prosecution with literally dozens of prosecution witnesses being called. And the bank of defendants that Sydney was allocated, so to speak, included Nelson Mandela. And remarkably, the defendants were on bail for the majority of the trial. They had to find their way from Johannesburg, where they typically lived, up to Pretoria, which in itself was a very difficult undertaking. But Sydney remembers this extraordinary experience of picking Nelson Mandela up from Johannesburg Central train station and driving him up every day to the courtroom in Pretoria and having these long conversations with his client, who at the time was a young man, but making his name as one of the great dissenters against the apartheid regime. Sydney remembers even then that he could see this great figure, the promise and the hope that lay with Mandela. And Sydney also remembers the extraordinary experience of going to a courtroom, just like any other courtroom in South Africa, where there were separate entrances to the courtroom. One which said Europeans on it, the other which said, using the language of the time, non-Europeans. The public gallery was divided in the same way. The lavatories of the courtroom were divided in the same way. The only place where the apartheid separation did not occur was in the witness box. There was only one witness box. And so eventually Mandela stepped into that witness box, and Sydney examined him in chief over a number of, I think, 3 days to draw out his political philosophy and his response to the charges. Now, one of the extraordinary aspects of that prosecution was that the state called as one of its principal witnesses, a professor of political theory from Cape Town University, who was an expert, as he classified himself, in communism. And it was his task to give evidence about how ANC literature, propaganda, not propaganda at all, the literature that was generated by the ANC, by the South African Communist Party, was revolutionary in tone. Now, Sydney thought very long and hard about this cross-examination. He tells me that he spent about a month preparing it, and that involved reading the works of Stalin, the works of Lenin, so that he could really properly undermine Professor Murray's evidence. And the transcript of the trial runs to, I should say, 25,000 pages. And I haven't read every single one of them, I should say. But I did read the cross-examination Sydney deployed against Professor Murray, which runs for 31 whole court days. It's an astonishing thing to read. And one of Sydney's favourite tactics to try and lighten the air occasionally was to put to Professor Murray certain quotations from anonymised people and to say, well, I'm going to read out something to you, Professor, and is that communistical? Read it out. And the professor, who was avid to find communism in every utterance, said, yes, definitively that's communistical. And then Sydney would say, do you know who wrote it? I don't know. Abraham Lincoln. And then President Wilson. And then another one, do you know who wrote that? No. Voltaire. Communistical. And then finally, the coup de grace was to read out another anonymous thing saying, is that communistical, Professor? Yes, it is. Do you know who wrote that? No. You did, Professor. It was an extraordinary experience for Sydney, for the defendants, in a very different way, of course. And remarkably, there were no juries involved. There were 3 judges, all of whom were closely associated with the government and the National Party. And after 3 years of evidence, quite remarkably, they acquitted every single defendant. And that's because still at that time, there was an adherence to the conception of the rule of law. It was an extraordinary outcome, one of Sydney's proudest moments. And it was the occasion when, I should say, Mandela was acquitted. We're not talking about the later trial, there was the Rivonia trial 3 years later, where Mandela was infamously convicted and sentenced to life in prison. Now, so that it was really that trial that inspired the title of the book. But as I was researching it, I talked to a treasurer of this inn, Sir Alan Ward, who was born in South Africa and spent the first 23 years or so of his life in South Africa. And he said to me, Tom, there's another story I need to tell you. He said, I was an attorney, a solicitor in Pretoria during the mid-50s, late 50s. And he said, I remember telephoning sitting in his chambers in Johannesburg and saying, look, I've been briefed by Mr. Mandela in a case, and he's asked if you would appear in the Pretoria court on his instructions to argue a particular case. And that's because Mandela, at the time, was a solicitor and attorney. He founded his own firm, the first black-run firm in South Africa, Mandela and Tambo, and he was instructing Sydney as counsel in cases even before Sydney met him as a client. Now, it was an extraordinary thought to think of Alan Ward phoning up Sydney and speaking to Sydney, and then 40 years later, discovering Sydney appearing as counsel in front of Alan, who was then in the Court of Appeal in this country, Sydney then as an advocate. Now, after Sydney's success in the treason trial, he would then go on to become really the leading anti-apartheid advocate in South Africa. And he remembers, he once told me, do you know what a mad world we lived in South Africa? He said, I appeared in a criminal trials, not civil trials, defending throughout my career in South Africa, 7 newspaper editors who were prosecuted for various forms of sedition, because so much was criminalized. And there was, of course, a very substantial impositions on freedom of the press during that period. He said, I acted for 2 university professors who were prosecuted the criminal trial, the criminal charges. A QC, his own colleague in Chambers, his great friend, a very famous and great figure called Brian Fisher, who was prosecuted for treason and sedition, and who Sydney found himself having to defend and willingly, of course, willingly defend. And this QC, Brian Fisher, who defended Mandela in the Rivoli trial, was convicted and sentenced to life in prison for treason, as it was described in those days. Sydney said, I also, so mad was that world, I also found myself defending on charges of sedition the Anglican Dean of Johannesburg, who was prosecuted for allegedly seditious activities. And that's not before we get to Desmond Tutu, he defended Winnie Mandela, Nelson's wife, of course, who he defended on a number of occasions, and Chief Albert Luthuli, the president of the ANC. And Sydney's very keen to say that these were prosecutions which he did win quite a few of them. It wasn't as if they were just pure placement on the bench. We're not talking about Soviet Russia or Nazi Germany, where there was a 0% prospect of acquittal. He, of course, lost a lot of cases, Sydney, through no fault of his, but he also won an awful lot of cases as well, because there remained on the bench for a considerable period of time that adherence to the rule of law, which had been such a bedrock of South African jurisprudence for many decades before the apartheid regime came into play. But Sydney could see the way things were moving, and gradually those independent-minded judges were retiring and being replaced by pure national party placement. And it became more and more difficult to get a fair trial. Life at the South African bar became more and more despairing, really, for people like Sydney. And the apogee, or the nadir, really, of that experience was the case which Sydney is probably best known for, which is the inquest into the death of Steve Biko, which I'm sure many of you will recall being the subject of an awful lot of literature and films, and occurred in 1977. You'll remember that Steve Biko was a great figure within the Black consciousness movement, as it was then known, and was beaten to death in a police cell in September 1977. And then there was an inquest into the circumstances of his death. And Sydney was retained on behalf of his family, Biko's family, and really over a period of 2 weeks, in the same old synagogue that Sydney had appeared in so many times before, which was the case where so many of the political trials took place in South Africa, in Pretoria. In that same courtroom, Sydney cross-examined police officer after police officer, prison guard after prison guard, and really laid bare before the world as a whole the brutality of the apartheid regime. And some of the cross-examinations that Sydney deployed, engaged in during those two weeks, have gone down in history as the kind of critical moments in South African legal history. Now, what was so depressing in Sydney in one sense was that, having destroyed via cross-examination so many of these witnesses who came up with this absurd evidence about the circumstances of Biko's death, what was so despairing for Sydney is then the chief magistrate, who'd been hearing this evidence and reportedly been listening to it carefully, then comes back into court to deliver his findings on the circumstances of Biko's death, and reads out his verdict, which is 2 sentences long, and which read as follows: "The available evidence does not prove that the death was brought about by any act or omission involving or amounting to an offence on the part of any person." That completes this inquest. And it was a terrible moment for Sydney and for many other people. But paradoxically, even though it was a defeat in one sense, on the wider world stage, it was a victory, because it was covered, the inquest was covered across the world. And it really was that case that I think brought the world's attention to the full extent of the iniquities of that regime. And in fact, it was such a famous case that it then became the subject of a play, which was put on a few years later in London, then became a film, in which no less a figure than Albert Luthuli played Sydney. And it's a 2-hour play, a condensed version of the inquest. And I have to tell the story, it's been told many times before, of Sydney went to the first night of the play in Hammersmith in 1984, and was sitting unobtrusively in the audience, and the actor playing the magistrate comes in and turns to Finney, who's playing Sydney, and says, "Yes, Mr. Kentridge," the way that the judge would do when turning to the advocate. And Sydney was so caught up in the moment, so it was said, that he stood up in the audience. How apocryphal that story is, I won't comment on. Now, there's no recording of Sydney's advocacy that I'm aware of, but many people have committed their memories to paper of hearing Sydney in action. Of course, many of his juniors, which he had many hundreds, are very much alive and there to tell their memories. And let me just read out to you one of his juniors' accounts of hearing Sydney in action. Quotation: "Kentridge was the advocate of his age, perhaps of the ages. What made him so? He has the natural gift of a deep baritone voice and the acquired ones of a deliberate fluency and perfect timing and delivery. He was unrelenting. In court, he spoke in carefully constructed sentences, often whole paragraphs. His manner was cool and ironic, cold and with a slashing sarcasm when angry. He was very well read, and his humour was always very dry." Let me read out another account, this time by a journalist listening to Sydney during a trial in the late 1960s. And I quote again, when he was defending a newspaper editor on a trial that lasted about 100 days. Quotes: "When Kentridge pursued cross-examination, the judge's face went red and his head tilted back as he visibly struggled to control his temper, because he couldn't bear Sydney's devastating cross-examination of the vast numbers of bogus witnesses that were giving evidence. Kentridge dealt with him without ever raising his voice. He would turn sideways and address the judge with cold contempt. In Kentridge's mouth, the ritual phrase, 'as your lordship pleases,' sounded a total insult, and the judge knew it and would burst into shouting. Then, realizing that he'd lost control, the judge would abruptly adjourn the court, stalk out, and return a few minutes later." Now, those of you who are students of this I wouldn't necessarily encourage that form of behaviour towards judges, at least in your first years of practice. There are just two little anecdotes that I love about Sydney and about his behaviour in court. The first is that it was often said by older judges in South Africa when talking to younger judges that, look, if you ever have Kentridge in your court, never give an extempore judgment, because you're likely to be so mesmerized by what he's saying that you'll immediately instinctively think that he must be right. Always reserve judgment so you can think a bit further about your decision, so you get a bit of distance between you and Sydney's advocacy. That's the first point. I hope there's everything like me, but perhaps not. The second anecdote, which tells you something about Sydney's wit in court, the story's been told before. There's a case where Sydney gets up to complain about the prolixity of his opponent's advocacy. And the judge, who's a mild man figure, says, yes, Mr. Kentridge, I think we can accord Mr. X, his opponent, a little latitude, to which Sydney instantly responds, my lord, it's not the latitude I object to, it's the longitude, which is I wish I'd thought of that. Now I'm conscious I'm slightly overrunning, so I'm going to sit down in 5 minutes, Treasurer. Sydney gradually moved his practice to London during the 1970s and 80s, although he still did an immense amount of work in South Africa in the 1980s. But after the apartheid regime had come to an end, he was invited to return to South Africa to sit as an adjunct judge of the newly formed Constitutional Court in 1994. And he spent about 6 or 9 months sitting, while in practice in London, sitting as a judge of this newly formed and enormously important court. And one of the first cases the Constitutional Court had to entertain, had to listen to, was a challenge made to the constitutionality of the death penalty under the newly created and post-apartheid constitution. And Sydney, amongst other judges who sat on the same panel, delivered a judgment holding that the death penalty was indeed unconstitutional. The outcome of which was that about 300 people who were all on death row, and South Africa was the most prolific executioner of its own people, I think outside of North Korea and China at the time. 300 people were thereby effectively, they weren't released from prison, of course, but they had the death penalty, the fear and terror of the death penalty removed from them. And I asked Sydney, well, what were your thoughts when you delivered that judgment to me? He said, I remembered back to my own experience of hearing the death penalty being pronounced on people back when I was a young man. And he said, I remembered back to going to visit clients in prison in South Africa, some of whom were on death row, and hearing the sound that whenever the sheriff came to take, and this was the way it was done in South Africa at the time, to say to a particular prisoner, the time has come for you to be executed, to be led to the execution chamber. And when the news filtered around the prison, there'll be this wailing amongst all the prisoners. Sydney said, if you ever heard that wailing, you'd never, ever, ever want a world in which the death penalty existed. I had a few more things to say, Treasurer. I think I've run out of time. Sydney was to
say all of those things when we have our panel discussion.
exactly. So on that, I have uplifting notes. Of declaring, it's not often you get an opportunity to declare the death penalty unconstitutional. I shall sit down. Thank you very much.